I gather, as you can see, we have a problem with the CVP on which the claimant was following. I'm sorry about that, but we don't know how long it'll take to fix. So I think we will just have to proceed. She can, of course, still watch it on live stream. The only difference is that it's 30 seconds behind or 2 minutes. I forget what the anyway, shortly behind. So if someone can just explain to her that we can't, I'm afraid, wait for this to be sorted out, and that she can follow it on live stream. Is there someone who can send her an email?
I can do that. I'm my own friend on this for you.
Okay. Are you happy to do that while we go on?
Yes, I am. Yes.
Otherwise, we'll rise for a moment. Yeah. Thank you.
My lords, can I summarise where we before lunch?
Yes.
In relation to the legitimate aim in round one, being the external, internal applicant. My Lord Justice Lewis made the point that at the time the 1998 Act was passed, the legitimate aim could be put forward as to protect workers who make public interest disclosures from detriment by an employer. Our position is, on ground one, leaving ground two for aside at the moment, because the legitimate aim is a legal construct which is reached looking at the underlying social purpose of the legislation. That when construing the legitimate aim, one looks
construing it. Oh, I see. I suppose.
And determining it.
Yeah. Okay. Yep. Yep.
One looks at it now in the light of the legislative changes that have been made. Mm-hmm. If my lords are not with us on that point, then I can move on to ground two, if I may. But you have the point. Because, of course, if it's determined now, looking at the scheme of the legislation, then we say that it has to take into account the NHS changes, and therefore it's not rationally connected with the treatment.
In that case, what's the difference in NHS between ground one and ground two?
Well,
they both depend on the changes made in 2015.
Yes, or ground one may not be as strong as ground two. I feel I should move on to ground two because it really goes to the core of what we say the differential treatment is. So,
differential treatment will be what we see in subsection 3, dealing with NHS applicants.
Yes,
which is not the same differential treatment as you see under section 47B. And which doesn't accord with the relief you're seeking.
Yes, my lord, if one looks at the differential treatment as arising from the individual statutory provisions, yes.
Well, it's part and parcel of the analysis, isn't it? The differential treatment is the difference in the statute.
Yes. Can I move on to the legitimate aim in relation to ground two? The department, as per their skeleton argument at paragraph 78, this is in the core bundle at page 76, states this, that limiting whistleblowing protection to NHS applicants has particularly happened in the NHS in the light of the specific nature of that field and the risks to those using the NHS. But for the reasons set out by Mr. Jupp before lunch, we say that the actual provision is significantly wider and not connected with any necessary element of patient safety.
Sorry, can you speak up a little?
Sorry, we say that the actual provision is significantly wider and not necessarily connected with any element of patient safety or the specific nature of the NHS field. We say that 49B provides whistleblowing protection to applicants for human resources and administration jobs. The NHS is an enormous employer, and there is a vast array of
We got the point.
yes. Moreover, it's those applicants who are directly analogous to the appellant's case, because it was an administrative role she was applying for. The second intervener protect point out, well, it's a small point, and I don't anticipate it will be an issue, but of course there is no unitary employer in the NHS. The NHS isn't an employer in itself. This is in response to a point made by the respondent. And so when one is applying for a job in the NHS, firstly, as Mr. Jupp says, that might be your first job in the NHS. You may have come from the private sector. And secondly, even if you are in the NHS, you may well be moving from trust to trust. And so there is no continuity of a single NHS employer in terms of...
That's obviously true, but I don't understand where it goes.
Well, my understanding is that the respondent had raised it in relation to the integrated into the workforce point, and it perhaps goes to analogous situation more than the justification analysis, but the point.
Anyway, that's the point, right?
Yes.
But we established early on, I asked this question very early on, people who've never worked in the NHS
Yes.
would still qualify as an applicant, just looking at the words of the legislation.
Yeah.
So if we're on to purpose, or the aim of the legislation, all we know is that by 2015, the purpose or aim of the legislation was to protect those in a contractual employment relationship and applicants for posts with NHS bodies. That's all we know. That's the purpose.
Well, I'll come to that, Monroe, because I do want to take you through the way in which the amendments happened and the Hansard in that respect. Another important point in my submission is that we do know that NHS applicants are not uniquely vulnerable to blacklisting.
Are not what? Uniquely vulnerable?
To blacklisting.
No, of course not.
And we know that blacklisting is, and detriments in respect of public interest disclosures which may impact on applicants for employment, is a concern in other areas. We know that from Protect's evidence and intervention. If the legitimate aim of the 49B of the NHS amendment is solely centred around patient safety, then we say the scope of the provision isn't rationally connected to it because it goes far wider than the second limb of the Bank Act. We also say a different way of looking at that is that the legitimate aim of the legislation is wider than the protection of applicants just relating to patient safety. And if that is correct, then we say again the restrictions at the NHS cannot be rationally connected to it. There is authority in Woodward, which is then cited by Mr. Justice Langstaff in Elstone, which sets out a wide purpose of the whistleblowing legislation. Could I take you to that? So that's Woodward, which is in the first bundle of authorities at tab 15. Page 310 of the bundle, paragraph 58.
Paragraph 68, did you say?
Yes,
Okay. Do you want us to read it?
yes, please.
Let's just read it. Yes, how does that assist?
We say it sets out the broad purpose of the legislation being to protect individuals who make public interest disclosures.
No certain disclosures of information, and the question is what you can't ignore the fact that says the public interest is protecting individuals who make certain disclosures. You can't work out what the disclosures are from the long title. You've got to go to the Act for that.
Very well, my lord. The position, as I set it out in relation to 49B in the NHS amendment, we say is this: if it is then restricted to the purpose of that, and it is restricted to patient safety, and we'll go to the parliamentary materials in a moment, that it isn't, that it's far wider than that, and therefore, when looking at the differential treatment in this case, you can say it's not rationally connected with the legitimate aim. And you can say that the differential treatment of this appellant in contradistinction to an applicant who is within the NHS for a purely administrative role isn't justified.
Well, no, it's the wrong way round. The legislation protects two groups of people, those in contracts of employment and those applying for NHS jobs. The legislation providing for that is clearly connected to it because it defines who those groups are. Your problem, you say, is that it's wrong to exclude other people. And the question is the exclusion of other people justified? And that depends on the kinds of things in SC. Is it a suspect ground? Did Parliament look at it? What is the effect on individuals of the legislation? So I can't understand at the moment how you're dealing with this legislation on what's the purpose or aim of the legislation, and then saying that there's some problem in the legislation being drafted as it is. To work out the purpose, you look at the legislation as it's drafted.
Yes, my lord. But if the purpose put forward, and we'll come to the parliamentary material in a moment, is to protect patient safety, it goes significantly wider than that. And
We know that, by the way. Well, how do we know it goes wider than patient safety? The fact that it has administrators and HR doesn't seem to me to mean that they can't be involved in patient safety issues. On the contrary, it's very often managers who cover up, and managers or HR people who become aware of clinicians who cover up. So I'm not quite sure what point you're making, but the mere fact that applicants for those kinds of jobs that their own role will not be clinical roles doesn't mean that they don't have the opportunity to make disclosures relating to patient safety. Now, maybe the drafting of the Act goes beyond issues about patient safety, might go to issues about financial peculation and so on. But that's a different point. It's not the point you're making.
could I move on to whether the difference in treatment had been considered?
Yeah.
So the law on this point is set out in my Lord Reed's judgment in SC, starting at 74, 174. I beg your pardon. So that's 48, page 157.
Sorry, which page? Which page did you say?
Page 1587, I beg your pardon.
1587. Yes.
So I summarise certain points from that. Firstly, occasions when resort to Hansard.
So sorry. Which passage are you making submissions about? The one starting at 174.
Yes, so and from isolating certain points, my lord, from 175. There may be occasion for the courts when conducting statutory compatibility exercise to have regard to matters stated in Parliament.
Yeah.
Then followed by necessary implications. That followed by necessary implications from the HRA. In the next paragraph, he said that he expected that occasions when resort to Hansard is necessary as part of the compatibility exercise will seldom arise. Ministers should such occasion arise, must be careful not. Sorry, courts must be careful not.
Sorry, where are you reading from now?
Sorry, that was the next line within paragraph.
Oh, I see. Sorry, I thought you'd moved to 176.
No,
I have
and
it.
I did
Yeah, I
the-
have it. Yeah. Well, this is in the next paragraph. I thought you meant in the next paragraph.
No, that's,
Yeah, sorry. Okay, I've got that. Thank you. Yep.
and secondly, moving down to 178. Authorities since Wilson have generally followed the approach he set out there, using Hansard as an aid to ascertaining the purpose as opposed to assessing proportionality. But then Lord Reed goes on to the purpose it may be put, and integral to this is the role of the Strasbourg court. So moving down to 180 to 181, as Lord Bingham explained in the countryside case, the degree of respect which the court should show to primary legislation in this context.
Sorry. Yeah, I can't quite hear you.
Sorry, moving down to paragraph 180, my lord.
180.
Yeah. As Lord Bingham explained in the Countryside Alliance case, the degree of respect which the courts should show to primary legislation in this context will depend on the circumstances, among the relevant factors, subject matter, whether it is relatively recent or dates from an age with different values from the present time. That's a reference back to Dudgeon in the United Kingdom.
Yeah.
So I take the point about the length of time there. And then 181.
Well, no, you've got to read the next sentence. Surely, Mr. Rowbottom. Another factor which may be relevant is whether Parliament can be taken to have made its own judgment of the issues which are relevant to the court's assessment. If so, the court will be more inclined to expect Parliament's decision out of respect for democratic decision making. And it adds a caveat to that at 183. Saying you can check whether Parliament considered it, but you don't mark its homework and say how good was the consideration.
Yes, I didn't mean to miss out part that was seemingly unfavourable, my lord. I was about to go to the.
I thought you were going to 181
Yeah, yes, but I was going to go to 183. I wasn't.
or 183. Okay.
Sorry, I didn't mean next. I meant I was going to take to that big part. Whether the legislation has considered the matters relevant to compatibility is important, we say.
Sorry, I got confused there. Where are you reading from?
I was 181.
181. Sorry, yep.
That's because the European Court takes account of whether the legislation has considered the matters which are relevant to the measure's compatibility with the Convention, although this is by no means determinative. Since the European Court is likely to take that into account, the objective of the Human Rights Act suggests domestic courts should do likewise in order to enable Convention rights to be properly enforced domestically. And I only sought to isolate certain points from this, my lords. I'm not trying to say that any one aspect of it particularly carry more weight than others, but paragraph 83, the two important caveats. Firstly, the court should go no further than ascertaining whether the matters relevant to compatibility were raised during the legislative process, and secondly, the courts must not treat the absence of poverty of debate in Parliament as a reason for supporting the finding of incompatibility. Now, the department has put forward material, including Hansard and consultation responses, that sets out how the legislative framework is developed. We say it's important to look at the chronology of that, the starting point, and this is all in the supplementary bundle, my lords. The starting point for the points I wish to make is page 92 of the supplementary bundle. And this was a June 2014 government consultation response to the whistleblowing framework call for evidence. Now, this did set out as an issue the possibility of extending protection to job applicants. It actually did it in two places, my lord, so I'll take you to both of those. The first is at page 92. Job applicants. So the government asked about the problems associated with regaining employment should whistleblowing lead to a loss of employment. Analysis of responses, we understand from the responses that some whistleblowers struggle to find new employment after they blew the whistle in a previous employment. Some respondents allege that a form of blacklisting can take place following a whistleblowing case. For example, references mentioning whistleblowing could potentially prevent an individual securing a new post. Now the government's response isn't, and we say this is important to say there's no issue in relation to job applicants and whistleblowing. It's to set out the other ways in which the government has taken steps to deal with blacklisting generally. So that there's no consideration in that passage.
This isn't Parliament, this is just some government department.
I accept that.
I'm about to say there's no consideration in this passage of what?
Of the differential treatment, in the sense that the impact of blacklisted job applicants being prohibited from making tribunal claims.
Well, is that right? I mean, I don't know what I suppose what you mean by consideration. They are acknowledging that there is a problem of blacklisting. They are saying here are some other measures that we have put in place to meet blacklisting, and by necessary implication, we think those measures are adequate. Isn't that right?
Well,
or is that not a right way to read it?
Well, can I take you to the other way it's mentioned, my lord, and then perhaps it should be addressed as a whole. So if you go up to page 90.
Page
90.
90. Back to page.
So back to page 90. It's also addressed under. So that's under the headline of job applicants, but then under the headline definition of work, we asked if this definition was broad enough to capture the relevant groups who should be included in the protections. Analysis of responses. Respondents identified a number of groups not included in this definition and therefore did not automatically qualify for a legal remedy under the whistleblowing framework. The penultimate bullet point, job applicants and those who have ended their employment relationship. Respondents argued that these groups may be in a position to witness some form of malpractice that would be in the public interest to report. And then if you go down to the government response, the whistleblowing provisions under the ERA were created with employment rights in mind, but it may be suitable for providing a remedy for other groups in certain circumstances. Therefore, the provisions do not definitively exclude some members of these groups, for example, solicitors, consultants, and interns. It then considers three different issues under the next three paragraphs that don't apply here. And then the final paragraph, for the remaining groups, the government will not be making any changes at this point, but will continue to keep this area under review with a view to consulting if further changes are considered necessary and making legislative changes through the secondary legislation power introduced through the Enterprise and Regulatory Reform Act. Now, so we say that's a commitment to consider the issue further in relation to job applicants. What then happened was Robert Francis' report following the mid-staffs inquiry, which was in February 2015. So this is at tabs 10, 11 and 12 of the supplementary bundle. Could I take you to page 177?
Did you say 177?
Yes, my lord, I beg your pardon. You see it 9.17 under conclusion. So this is the section, the chapter of freedom to speak up on extending legal protection. 9.7. Although the existing legislation is weak, I've not recommended a wholesale review of 1996 for two reasons. I don't think legislative change can be implemented quickly enough to make a difference to those working in the NHS today. What is needed is a change in the
I
culture.
don't need to read all that. We read it through.
very well.
What's the particular point you're making from this?
Well, from the last part of that paragraph, second, this review is only concerned with the position of disclosures made within one part of the public sector of the NHS. So as we know, that exclusively dealt with that, the Francis report. Then one moves to paragraph 9.19, which is the final paragraph of the chapter. And the second half of that paragraph, with that in mind, I think consideration does need to be given to extending discrimination law to protect those who make it a protected disclosure from discrimination, either in the Employment Rights Act 1996 or the Equality Act. Now, that was actually put into place very quickly by the government. So the debates...
Or by Parliament, which was it that put it into place?
I beg your pardon, my lord.
Both.
Was it...
It was Parliament, I think, that put it
Well,
into place because they amended the Act, didn't they?
Yes, looking at it from a constitutional perspective, I was about to come to the Hansard where the bill is where the amendment was laid, my lord. So, hence the slip of the tongue. But I accept that. Tab 13 is the 11th of March, Lord's Hansard.
Just don't read the date of the. This is the Sir Robert Francis report. What date?
So that's February 2015.
Yeah.
The 11th of February 2015. Then exactly a month later, my lord, on the 11th of March 2015, you have the debate in the House of Lords. Now, there was a specific amendment put forward to the 2015 Act that would have extended general protection to
Page
applicants.
196.
Yes, my lord. Now, that was put forward by Lord Wills. He raised specifically the objection that it wasn't just NHS workers who required protection. The response of Baroness Neville Rolfe on behalf of the government is set out at page 200 to 201.
Yeah. And then there's a vote on it, was there?
Yes.
And the vote wasn't carried.
I think it was... Yes, it was disagreed.
So why isn't this exactly what SC says? Was it considered by Parliament? Answer, as an historical fact, it was, because there was an amendment moved which would cover exactly what your client's position is in. There was a debate about it. We don't mark or assess the quality or reasons for it. We know that this was something that Parliament considered and decided against, and that's a factor, but not a conclusive factor, in deciding whether the balance that's been struck is justified.
Because it's the difference in treatment that is the relevant consideration model for SC purposes, and because when one drills down into this, what Baroness Neville Rolfe's repeated responses, we don't have the evidence
But I thought SC said we weren't supposed to drill down. We asked whether it's considered by Parliament, and the answer is they don't think at the moment there's a sufficient evidential framework to justify going further. And that's a factor. We don't assess whether that's right or wrong. It's a factor in the assessment. Now, I don't see where what you're asking us to do at the moment is compatible with SC.
So one can use Hansard for the limited purpose of deciding whether the values relevant to the difference in treatment have been considered by Parliament. And my submission is this, my lord: when one looks at the reply of Baroness Neville Rolfe, what she is saying is, we've just had this report, we're making the change for the NHS because we haven't got, but we don't have the evidence in relation to wider whistleblowing as things stand. And that you can see that at page 201 on the left-hand column, fourth paragraph.
The left-hand column.
Yes. We are taking specific steps in relation to the NHS, and then there's another reply from Lord Wills, and underneath that, I am not sure we're going to agree this evening on extending to other areas. I've made clear that we need an evidence base and that we are doing things in other areas, the things that we are doing in other areas, to which I hope I will move on. But there's we say the actual difference in the treatment, i.e. the evidence base, what the impact is on non-NHS applicants, wasn't considered there.
But isn't that just playing with words? The question they asked themselves is, should we extend this to job applicants or not? And the answer was, by a majority of 231 to 174, no, we're not going to extend it. We don't go in to consider the reasons why not. She may have thought that there wasn't enough evidence. Other members of their Lordship's House may have thought that there are other reasons why not to do it. But aren't you asking us to do precisely what SC says in paragraph 183 we shouldn't be doing?
No, my lord, because SC at paragraph 183 is referring to a situation where someone goes through. I'm doing the opposite. I'm taking you to the parts where it was considered, where the legislative changes were considered, and saying there is reasoning there, but the reasoning is that they don't yet have the evidence in respect of non-NHS applicants. Taking into account that also a month before there was the government response saying we will keep the wider situation under review.
So really your point is that consideration for the purpose of the SC principles means substantive consideration.
Yeah.
And to identify there was no substantive consideration because there was no evidence doesn't count as, my lord puts it, marking Parliament's homework. It's not as if they had considered it, but we didn't like what appeared to be the answers insofar as we could infer them from the parliamentary debates. Is that the distinction you're making?
Look, I follow that, but then what are we supposed to do with that? How are we supposed to take into account and evaluate the absence of that material before Parliament?
Well, it's for the department to justify the differential treatment.
No, it's not. It's for Parliament. It's not the department's problem. It's Parliament's problem. They decided to go a certain way, but no further. And the question is whether the legislation enacted by the Parliament is justified, not the government. They may be the party in practical terms, or sometimes the Attorney General, but they're not justifying a government decision.
My lord, I meant as part of the forensic process that the burden of justification lies on the state as regards the HRA. To complete the chronology, we also have the response to the consultation regarding the protection of whistleblowers that preceded the 2018 regulations, because of course there was a gap between the primary legislation and the regulations that
Sorry, I'm just making a note. Where have we gone to?
So this is tab 14, my
Yeah.
lord, of the supplementary bundle.
Yes, sorry, I've got to it. Yeah.
I can
Where
take-
are we
I can-
going into?
Well, I can take this quite quickly, but there's no
Okay.
consideration there when laying it, because self-evidently this is the internal NHS issue.
So is this about the regulations now, or are we still dealing with matters to do with the legislation drafted by Parliament?
This is about. I was taking my lord through the chronology of how the legislation's developed. So
Right.
this is
But does this lead up to an affirmative resolution debate on the regulations?
there's no debate following this that's in the material.
So it's a negative resolution. Then.
I thought it was affirmative.
If it's affirmative, there must have been a debate.
No, I said there isn't one in the bundle.
Oh, I see.
There may have been one.
That's where Parliament would have considered the regulations
I bet. Sorry, it's the Baroness Mansell. Sorry. At tab 15, my lord,
Right,
there is.
so
the
this is all after the legislation's been passed now.
Primary
We've passed
legislation,
the primary legislation, and that says if the minister wants to, they can make regulations. And we're moving now, are we, to the making of the regulations by the relevant minister?
Yes.
Good.
But the making of the regulations surely is not really likely to be material for anyone's point, because the limited scope of the amendments being made had already been determined when the Act was passed.
Yes.
All the regs had to do was to identify, well, there may be all sorts of odds and ends, but it was just identifying which NHS bodies and
Yes.
at various procedural points. But so why does this Act help?
So the point that I wish to make simply shortly was this: when Baroness Mansell introduced the regulations, the reference at page 241 that was made. So in the second paragraph on the left-hand column, the whole point from the government's perspective, and I take the point that's the government's perspective, is that we need to ensure the culture within the NHS is changed so that those people who want to highlight poor practice in the NHS, who are concerned about patient safety, have the right to speak up. Very important that these rights are protected. So I was taking you through the chronology of the material presented by the department to make the point that the values relevant to the differential treatment in this case, respective NHS applicants against non-NHS applicants, haven't actually been considered, because there hasn't been any consideration in Parliament, despite the fact there has been debate.
Yes,
so I'm not
but picking up my Lord Justice Underhill's question, if you go to right-hand column 239, halfway down, without reading it out, starting with the paragraph, I realise this is not pertinent to this statutory instrument. That here then asks, why not other sectors? And the answer comes back at 240, right-hand column, halfway down, Baroness Mansell. And the short answer is we're operating within the scope of the primary legislation.
Yeah.
So you wouldn't expect this material to offer help on the question that we're addressing.
No, very well, my lord. I may have been trying to be too thorough. You also have, DBT is also, it relies on Labour's plan to make work pay and the current employment rights bill.
Sorry, can you speak up a little?
It has filed with its skeleton argument Labour's plan to make work pay and the current employment rights bill. Those, although Labour's plan to make work pay refers to strengthening whistleblowing protection, particularly in respect of harassment, and it refers to potential for other areas, but there is nothing in the employment rights bill that would deal with the issue that's before this court.
So your submission is really this, that although they considered whether or not to include applicants, that's not a relevant factor pointing to a degree of respect on our part, because they say when we go through the debates that they didn't have the evidence to justify extending it, and therefore that's the same as no consideration. And we're into the other part of Lord Reid and Baroness Hale, that where Parliament have not considered it, we don't need to be concerned.
I don't accept, my lord, that I'm asking this court to rely on an absence of parliamentary debate in the way contemplated by SC. The submission is this: in 2014, the government committed to keeping the area, this issue under review, the extension of job applicant protection. In 2015, in relation to an amendment which was voted down, the government said that they had particular evidence in relation to the NHS, but there was no evidence, they hadn't been sufficient consideration to form a
Parliament
legislative
had
change.
an amendment saying include job applicants, and Parliament voted against an amendment.
I mean, you were saying what your submission was. Your submission was in 2015, in effect, they still said the same. They didn't just say there's no evidence. They said we're continuing to consult.
They didn't quite say that. They said there's no evidential base for making the same change outside the NHS.
But didn't they say a bit more than that?
Yeah.
I'm sorry, I may as well get this right. I may have misread it. Where's
So it's page 200 to 201 of the supplementary bundle.
I thought I saw, but perhaps I didn't. In the right-hand column somewhere, something referring back to a.
So the issue is raised with Baroness Neville, and then she comes back and says, we have very good evidence from the Francis Review. This is on the right-hand side at 6 p.m. We do not have evidence for all other sectors, and of course the amendment would have to apply to the private sector, and the coverage would be very wide-ranging.
Between the two hole punches, there's something about considering the steps we've taken to review employment legislation and whistleblower legislation. I don't believe it's necessary to introduce another review next year. Yes, I see. Okay, I may have misread it.
I'm not seeking to put it any higher than that, my lord, and I was taking you carefully to the points where this has been considered in parliamentary debate.
Well, I'm sorry to be slow.
No.
But I can see that there's the absence of this information. But what, in terms of legal analysis, is the relevance of that to the proportionality issue? What do we do with that, if anything?
That it means, my lord, that the difference in treatment vis-a-vis the NHS ground, the values relevant to it, i.e. whether the scope of NHS roles goes beyond patient safety and the extent to which blacklisting and detrimental treatment as a result of public interest disclosures impacts on non-NHS applicants, that because that hasn't been considered, the values relevant to the difference in treatment haven't considered, and that therefore this court cannot find the differential, or should not find the differential treatment justified.
So in other words, sorry. I was going to say the upshot, the corollary of that is the court, in a different case, could only come to the opposite conclusion if that information had been gathered.
Obviously, it's one factor, and it goes to both the
That's
margin
fine.
and the proportionality.
I must say, I thought this was all just going to a negative, basically to say, don't believe all this stuff the government's putting forward about how it's been consulted by Parliament. Don't attach weight to that, considered by Parliament. Don't attach weight to that, because when we look at actually how it was dealt with in Parliament, we can see it wasn't considered by Parliament.
Yes, well,
I thought that was all. That was what all this was going to. It's negating a point relied on by Mr. Moretto. Have I got that wrong?
Well, no, that is right, and it also narrows the margin.
Well, then
we
obviously
say-
that factor comes out of the margin equation. Yes.
The difficulty I've got, you've shown us the comments of one member of the House of Lords, and I'm sure she's tremendously eminent, and she's a government minister, and I pay great respect to Baroness Neville Rolfe. But at the end of the debate, Lord Wills, who moved the debate, comes back to it, and he says, no, you're wrong. And he says in the second full paragraph on 704, I can see no good reason for the government not to accept this. There's no good argument for confining protection to the NHS. The Minister made great play of the need to acquire more evidence. There are two problems with that report, and he identifies them. Then he goes on to say, if we persist with the desire for more evidence and so on, where are we going to get to? He says, I want to encourage them to think again, and he pushes it to a vote. So you've got clear arguments on the one hand. You have the Baroness saying, no, we don't think we've got enough evidence. You've got Lord Wills saying, oh, don't keep going on about evidence to me. We know what the position is. And Parliament takes a view. And the view they take, and we don't know the reason causing the 231 to vote not content, was that 231 of them said, no, we aren't going to the stage yet of protecting job applicants other than applicants for posts with NHS bodies. So I don't understand how that isn't a consideration by Parliament of the substance of the amendment, should or should it not be extended to job applicants. I don't see how you can assume they haven't considered what you call the values. Is it right or wrong to protect these people? You focused on the comments of one member of the Parliament, albeit an important one. That's the difficulty that I have.
If I'm not seeking to get into a debate back and forth on the contents of the debate, I accept that's not what SE intends in respect of Hansard. I've made my submissions, my lord, on what was said. I concentrated on what the Minister was saying because there had been the government commitment to keeping the issue under review in the consultation. I take the point that there was a vote in Parliament and that there was debate back and forth. I'd normally ask if I could turn my back, but I think I probably should look forward towards my leader. Can I just set that? Can I help any further, Miles?
Yep. Thank you very much indeed, Mr.
My Lord, very briefly, I'll deal with remedy and reading down the declaration of incompatibility. I've set out in our skeleton argument, page 38, paragraph 74, right at the bottom of the page, with thereafter 5 principles which we say, and which you will be familiar with, that I also can draw from the Godin-Mendoza case when it comes to the approach to reading down statutes. I don't propose to deal with those in detail. The authorities in the bundle and the relevant paragraphs are referred to. I want to deal firstly with the principal objection, which is to suggest it would go against the grain of the legislation. I've made the point already that we are not seeking to extend whistleblowing rights to the public at large. That, of course, would go against the grain of the legislation. All that we are seeking is to extend the statute, which I've already said, it covers the employment field to job applicants. That is, applicants for employment as defined in the statute. That, we submit, does not go at all against the grain, it goes with the grain. It's consistent with all of the extensions and interpretation of the statute to date. I'm not going to go back over all of that, but we've got it through the McClellan, we've got it through Woodward, we've got it through all of the cases where both at either end of the employment relationship, rights have been extended. So extending it to job applicants doesn't go against the grain. It runs with the purpose, the underlying purpose of the legislation, which is protection within the employment field. We're not talking about protection in goods and services or protection in any other field. We're talking about solely protection within the employment field. So to that extent,
Obviously, I see that point. And I don't say it would be, but it might be a strong point if we weren't aware that from the legislative history that there had been specific parliamentary consideration of whether to extend it to job applicants. The points we've just been looking at in a different context surely come back and create a difficulty for you here too, don't they? That, or perhaps more, how can we say, in terms where Parliament has actually, in terms, in its debate, said no, not job applicants generally, to say it goes with the grain of the legislation? Well, I agree it's a metaphor. It's one we all tend to use, but I think if you look at other passages in Gaidan, what they're really looking at is points which are cardinal features of the legislation. And if you ask yourself, is this a cardinal feature of the legislation, you would have, I would have thought, to say yes, because it is designed, because the parameters or the limits of the people whose rights are granted is a cardinal feature, and one to which Parliament has paid recent and special attention. What would your response to that be in the Section 3 context?
my lord, I think if my lord's got to the point of saying that the people in the claimant's position, that their Article 10 rights, when read with Article 14, they had suffered discrimination in relation to those rights, then when one looks at the Employment Rights Act, particularly Part 4A, one can see, even within the context of that legislation, incremental change over the years. So we have the extension of worker, we have the extension to the NHS job applicants. It's not, in my submission, it would not be inappropriate at all for this court to look at that swathe of general expansion of rights within that part of the Act and say that this is simply another incremental change which is going with that broad change over time. The fact that Parliament has considered it, and as Lord Lewis has pointed out, on a vote has declined to extend to job applicants, doesn't really tell us anything about the grain of the legislation, I submit.
Well, I'm trying to get away from that metaphor.
Yes.
And I am right, aren't I? We could look at Gaidan if we need to.
I think it may be helpful to
I
look
think the
at
phrase cardinal feature is actually used in one of the other speeches.
If we start perhaps with Lord Nicholls' speech at page 144 of the authorities bundle. Under 1.
Really, just two big speeches. I mean, other people give speeches, but on this point, it's Lord Nicholls and Lord Roger, I think. Yes, Lord Nicholls, yes. 30, did you say?
Sorry, yes. Sorry, just Lord Stayne and Lord Nicholls both gave detailed speeches in this case. So that's really the starting point.
Yeah, well, yes, it's 33. I misremembered the word cardinal, but it's the word fundamental, which is much the same. 33 cannot have intended the discharge of this extended interpretative function, the court should adopt a meaning inconsistent with a fundamental feature of the legislation. That would cross the constitutional boundary. And what I'm putting to you, I mean, maybe there's not very much more you can say, but that who the legislation gives rights to would probably always be a fundamental feature, at least where it's perfectly explicit who it gives them to and who it doesn't. And even if it isn't, it's certainly a fundamental feature once we know that Parliament has recently considered whether to extend that category and has decided not to. That's what I'm putting to
My
you.
lord, I understand the point. I think, my submission rather is that in relation to that expression fundamental feature, one is really talking about the thrust of this legislation. What is it designed to do? And that is to protect people in the employment field.
Yes, I see.
I think I'm slightly repeating myself, but the extension to job applicants, or we take a step back, started with workers and employees. That was who was covered, nobody else. We then had extension to various categories of individuals who are not workers and employees. They're in the
Well, they are workers and employees, aren't they? You change the definition of worker.
Yes, forgive me, you're
But
absolutely right. But within the definition of Section 230 of the Act, they wouldn't fall within the definition of worker and employee in some cases, but that has by definition been extended. And it's that incremental extension, and then we get to the NHS. And it's no doubt, if we waited long enough, we might well get to job applicants. But what we're saying here, in this case, is actually, my friend Mr. Rowbottom has essentially dealt with this point, that we haven't, that at this point in time, and on this point, we've got that incremental change, and extending it to job applicants isn't going to fundamentally alter the tenor of the legislation.
I see what your solution is, but I just wanted to put to you that it's particularly difficult to say it isn't a fundamental feature in circumstances where Parliament has rejected an amendment giving effect to it. But you would say it doesn't quite follow.
Yes, that's exactly what I would say. In terms of reading down, I've revisited that issue and taken a slightly different approach to that, which is in my skeleton argument. What we would start with is section 43K, which is page 21 of the authority funding. And it will be our submission that the easiest way of curing what we say is the difficulty would be as follows. So
Let's do this at dictation speed.
yes, so we have 43K, and then we have a variety of subsections, subsection 1, then a variety of further subsections, A through to over the page D. And after D, so after subsection D, insert the words subsection, so that's E, is an applicant for employment.
Okay, so I can use the one in your skeleton, but instead of changing applies for employment,
Just
put in is an applicant for.
and that's it, no more. Employment is defined in section 230, so we don't.
Oh, I see.
So that's the first part. Then there's a secondary addition.
Does that cover people? I mean, it's not a problem. Is or was an applicant? What about people who might be an applicant, but they ring up and they say, "Don't you apply? We know who you are." Don't you want is, was, or maybe? They have been,
Yes, well,
or would have been, but for the fact that they thought they were going to be blacklisted. I mean,
yes, there may be addition, is or may be an applicant for employment, maybe. Then the second change.
So that's not a substantive change, is it? To the text that you had in your skeleton at 76.
It shortens that considerably.
Just meant to have the same legal effect.
Yes, same legal effect, but we don't need the additional bit because having read back to 230, that would have been included. There is
So
a
it's more elegant.
yes. Well, thank you for that, my lord. There is an additional part which is not in my skeleton, which requires a bit of thought about. And one will see in the section we've just been looking at, subsection D, the next subsection is 2, which defines employer. For the purpose of this part, employer includes, and then there are a series of
Sorry, we better look at this. Sorry, we better go to the statute, have we?
Yes, sorry, and the page 22. So just to orientate my lord,
Yes.
you will see at the top of the page is D, and I've suggested we insert an E after D.
Yes, that bit I have.
Yes, and then we get to subsection 2, which
Yeah.
for the purpose of this part, employer includes, and then we add another subsection at the end of that, which would be a subsection D. And you will see the form that is used in the previous subsections. So in relation to subsection of that subsection, so I'll dictate, in relation to subsection E of that subsection.
It can't be subsection E of a sub. Must be paragraph E. What do you have after a subsection?
Sorry, forgive me. Paragraph E after that subsection. A person who, had they been appointed, would have been employed.
Sorry, I don't think I followed. This is 43K2 new D.
Yes, that's defining employer. In other words, the person whom you can sue.
Yes, in relation to paragraph E of that subsection, person who, had they
Sorry,
been...
sorry.
No, it can't be right.
No, sorry, forgive me.
Oh, that can't be
rephrase
right.
it. No, sorry. A person who had appointed the applicant.
A person who, had they appointed the
Yeah,
applicant,
yeah, would have been the employer.
no, would have been the employer.
Yes, exactly. The person who, had they appointed the applicant, would have been the employer.
No, would have been the employer.
Yes, exactly.
Oh, maybe I misheard you. Yep. Okay. Just shows how difficult parliamentary drafting is.
So that we submit as the appropriate form of word, or an appropriate form of word. I know protect.
There's lots of dicta
Yeah.
saying you don't actually have to
Yeah.
apply for a particular wording.
If you're against me on all of that, and I don't think I can really add anything to what you said, then we would submit it's an appropriate case for declaration of incompatibility.
Yes. And you say basically there has to be a very special reason not to make a declaration of incompatibility. You've got to that stage.
Those are our submissions, my lord, unless I can be ready for this.
Thank you very much, Mr.
Just a couple of quick questions. I mean, the reason for adding in that additional text is presumably because if we go back to section 47B, page 28 of the bund, if you just read in an extended definition of worker, that would enable an applicant to get the benefit of section 47B, subsection 1.
Exactly, my lord.
You have to read in additionally an extension of the concept of employer.
Yes.
That just emphasises that section 47B, subsection 1, is dealing with the relationship between workers and employers.
Lord, yes.
My question goes back to the amendment to 40. I'm so sorry. It was where you adjust
43K2.
43K. I'm so grateful. Thank you. As to whether this is with or without the grain or a fundamental change, if we just go through 43K, the first 4 subparagraphs are all people who works or worked. what they're doing is to take people who work or have worked and extend section 230, subsection 3, by reference to the nature of the relationships.
My lord,
Worked or
yes.
worked, but it's all work focused. The E is slightly different. That's the D, I beg your pardon. That's work experience.
I mean, that's an important distinction because the work experience is often not paid. There's often not a contract in place.
No, but you are working. You're in the institution doing stuff.
But it comes back to a point which I've already, I think, labelled
Yeah.
to some extent, which is you're getting gradations of relationship.
Whereas I think a point which is being made against you is that in relation to the applicant scenario, there may be no work at all.
That may be the case.
Sorry, thank you. That was my only question.
Before I conclude, I just tell my lords that we have collated the documents my lord asked for, and I will bring hard copies of those tomorrow morning. I can email them over to the court this evening.
If you would do both, we're most grateful. Thank you for doing that. It's probably not you personally, so I should be thanking someone in the room or outside the room. Yes. Yes, Ms. Darwin.
My lords, I appeal on behalf of Protect, the well-known whistleblowing charity, along with Mr. Roberts, who sits behind me. Protect's chief executive, Ms. Gardner, also sits behind me, along with my instructing solicitors from Farrow & Co. My lords, at the heart of this appeal is the risk of retaliation faced by individuals who speak up and raise concerns. A fascinating experiment explained in Ms. Gardner's witness statement, which you have in the additional bundle, shows that even before students enter the workplace, students asked whether they would blow the whistle about a health and safety concern, a very serious one, overwhelmingly said they wouldn't, because those students understood that to blow the whistle might render them unemployable. Not just that it would cause difficulties with their immediate employer, but that it would risk their ability to find future work. And Miss Gardner's evidence is that those students' concern was well-founded. She says in her witness statement that too many whistleblowers are effectively excluded from the ability to work again in their chosen field. And she cites a study which suggests, based on anecdotal evidence, that whistleblowers who survive their experience often change careers, even change countries. And we know that when Sir Robert Francis KC looked into reporting cultures within the NHS, that he concluded much the same. And the first paragraph of the conclusion to his report you have at page 93 of the additional bundle. And if I could just invite you to turn that up. Paragraph 10.1 at the very top of page 93. It is clear that the concerns which led to the setting up of this review are justified. While incidents and reports are often handled in accordance with good practice, there is a fear shared by many NHS staff that they will suffer adverse consequences if they raise concerns. Just as worrying is the commonly held belief that nothing effective will be done about concerns if they are raised. And if we then turn to look at Principle 20 of his report, which you have at page 84 of the additional bundle, Principle 20 was extended.
Sorry, did you say the additional bundle?
Yes, apologies, my lord. You should have a bundle called the additional bundle, which very confusingly is different from the supplementary bundle.
No, exactly. I was looking at page 24 of the additional bundle.
Very good.
I don't see Principle 20.
84.
Oh, 84.
Principle 20, page 84, my
Yeah,
lord.
thank you.
Forgive me if I
No, it's probably I misheard, much more likely. Yep.
Principle 20, page 84, says extending the legal protection. And I wanted to particularly refer you to what is said at page 85, and that's paragraph 95. talking about here about whistleblowing legislation. He says the legislation applies to all employers, not only those in the NHS. So it would not be appropriate to make recommendations for amendment which might impact on other sectors in ways that I am not aware of. However, I am particularly concerned by one aspect of the legislation, which is that it does nothing to protect people who are seeking employment from discrimination on the grounds that they are known to be a whistleblower. This is an important omission which should be reviewed, at least in respect to the NHS. I invite the government to review the legislation to extend protection to include discrimination by employers in the NHS, if not more widely, either under the Employment Rights Act 1996 or under the Equality Act 2010.
Why does he refer to the Equality Act?
My lord, I'm not quite sure, but he does also refer to discrimination.
Yes,
So
I
he
see.
seems to be kind of conflating, which is a fair conflation, the concept of victimisation more broadly and victimisation
Yeah, no, I
against whistleblowers.
understand that. I just
Yes. And it may be also because some whistleblowing will also amount to protected acts under the equality legislation.
Under paragraph 101, I haven't read the whole report, but he says this will make the NHS a better place to work and a safer place for patients. So that's a general conclusion of extending it to applicants in the NHS sector generally, is it or is it not?
Well, my lord, I think you've picked up on a random paragraph in front of you, but I think that conclusion applies to the whole of his report. So without taking you through the whole of his report, or asking him, I don't know what he's particularly referring to at paragraph 101. But there we go. So that's principle 20 of his report, and that, of course, led to the making of the NHS regulations that you've already been told about, but I'm actually going to take you to. And we know, of course, and we don't dispute it, that Sir Robert was only tasked with looking at the culture in the NHS. But Miss Gardner's evidence is that the fear of suffering adverse consequences extends beyond the NHS, and that the same concerns apply across all sectors. And she's also explained to you that, like discrimination, retaliation by an employer for blowing the whistle is insidious. It's very difficult to prove. And you won't, of course, know why you've not been called to interview, why after being interviewed you've not got the job. But just to give you the example of Stella, not her real name, but referred to in Miss Gardner's evidence, she blew the whistle to the regulator, so not to her employer, to the regulator. She then found that she'd applied for 400 jobs, but was only called to 2 interviews. And from what we know about Stella from Ms. Gardner's witness statement, it appears that Stella's employer did in fact subject her to detriment for blowing the whistle, but assume that the employer hadn't done anything to Stella, that they accepted that she was right to blow the whistle to the regulator. Stella would not have any remedy because she hasn't got a claim against her employer, because her employer, hypothetically speaking, hasn't done anything wrong to her, and she's unable to bring a claim against any of the employers who've refused to employ her, the 400 employers potentially who've refused to employ her. And that would be the same even if she knows, because say she has a friend working in the organisation, that the exact reason she didn't get the job was because she'd blown the whistle to the regulator. So there is no remedy for this type of victimisation as the law currently stands. Our written submissions address...
Can I just ask?
Yes.
I think anyone who worked in the employment field would know that the point you made is an obvious concern, and would have been an obvious concern back in 1998 when PEDA came in. Do we know why there wasn't protection, why the original Act didn't provide for protection of applicants? Because, as I say, it's not as if this is some new phenomenon that...
My lord, I don't know why the original Act didn't provide, but just to give you one example of the many things that may have changed since 1998, Her Majesty's Courts and Tribunals Service have taken the decision to publish Employment Tribunal judgments. They don't publish judgments of equivalent first instance courts. So, for example, Social Security Tribunal judgments aren't published, County Court judgments aren't published. But Employment Tribunal judgments are. And we know that lots of employers will check individuals'
You
names
say we
against.
know that. How do we know that? Have we spoken to them? Is there evidence? It is a court. We must proceed on evidence, surely.
And so, my lord, that is one thing that you will, if anyone has brought a
I
whistleblower
don't.
claim,
Yeah,
that is in the public domain immediately.
because this was actually legislation promoted by
Yeah, by PCAW.
PCAW, as it then was, and a great achievement on their part.
Yes.
And I'm not getting to anyone, I'm just trying to understand why wasn't this something that was included in the original draft that they promoted?
What we know from Miss Gardner's witness statement, my lord, is that essentially this was rushed through. She doesn't use quite those words, and essentially inserted into the Employment Rights
Well,
Act
I have had to ask
1996.
this, not this question, but a similar question about,
Yes.
I mean, as you'll know from the case law, there are anomalies created by
Yes.
being put into this act,
Yes.
rather than where it might more naturally belong structurally in the equalities legislation. And so you've got sort of a slightly some equalities-based concept stuck into the unfair dismissal legislation.
Yes.
And I see that, and that may be the answer.
At the time, the legislation would obviously have protected both employees and workers, because the legislation would have included the general right to be protected against detriment, which applies to workers. That anomaly may explain it, but I can't give you.
No, I mean, well, this may be the answer, and I don't want to spend a lot of time on this unless there's anything helpful in it. But once the decision is taken to put it into the Employment Rights Act, I think I'm right in thinking that there are no areas, certainly weren't then any areas in which the Employment Rights Act gave rights to job applicants, whereas the equalities legislation gave rights to job applicants from the start.
And
but so it may be that the vehicle you chose to get it in
yes,
dictated this conclusion.
that might be right, my lord. It is right. The legislation does give right to job applicants, so we've set out some examples of
I know
that.
it does, of course. That's
Yes.
not the point I'm putting to you. But the Employment Rights Act,
Yes.
I don't think did
No.
or
It didn't. We don't think it did. But by way of example, my lord, by way of example, the Trade Union Labour Rights and Consolidation Act did give.
yes,
rights.
but that's irrelevant to the point
Yes.
we're considering. Okay, I probably explored that enough.
Can I just check two things? Actually, firstly, I don't see in the witness statement of Ms. Gardner, it'll help me because I haven't located it, where it says it was rushed or words to that effect. And the other thing is, I thought it began as a public interest disclosure bill, so it wasn't part of an existing employment bill. It was presumably a decision taken by whoever drafted the public interest disclosure bill to use the Employment Rights Act as a vehicle. Is that correct?
My lord, paragraph 16 on page 18.
That suggests that it was a matter of choice. They decided not to have a special tribunal, and they decided to use the Employment Tribunal and to use the ERA as a vehicle. But I don't see anything about it being rushed, and it does seem that this was a choice on the part of those who were promoting the Public Interest Disclosure Bill to use it as a vehicle to insert things into the Employment Rights Act.
Well,
Rights Act. Or
my
that's
lord,
wrong.
it says what you can see. It says, she says it was used the placement of PEDA within the wider employment rights legislation can then be seen as a matter of convenience. And then she goes on to explain many aspects of PEDA are unique among the other provisions of the Employment Rights Act 1996, such as the extended definition of worker and the anti-gagging provisions. So, my lords,
Well, yes, but in other respects, as you say, it had to plug into. And part of the advantage was you didn't have to reinvent the wheel. You had
Yes.
and compensation provisions and so forth.
yes.
Very well.
And-
Perhaps those behind you, if you don't have it in your head, can just remind me what, because we did, in fact, well, in one of the cases, I think it may well have been Chesterton, or it may have been, I can't remember. We probably the evidence from Miss Gardner or perhaps from her predecessor we alluded in the judgment to this choice.
Yes, I'm certainly, I can dig that out and certainly,
Someone can tell you, and you can tell me later.
yes. I
Okay,
can tell you later
carry
where I
on with
can
your
go. Sorry.
submissions.
I'm very grateful, my lord. I'm going to, you have our written submissions which address all the issues in the appeal, and those are in the additional bundle from page 115 onwards. In my oral submissions, I'm going to focus just on two issues, but those are firstly how the Employment Rights Act 1996 operates to protect whistleblowers, and secondly, how the NHS regulations operate to protect job applicants. The reason why I'm focusing on the domestic legislation is because what is said by the Department of Business and Trade submissions on justification is about how those two pieces of legislation operate, and we disagree with some of what is said about how they operate, and we're therefore grateful for the opportunity to make submissions on that.
Okay. It would help, I'm sure you're going to do this, if you let us know, as it were, in advance, which bits of Mr. Moretto's Stoughton argument you're...
I will. In fact,
Okay.
I'm going to take you paragraph by paragraph what you said in justification and
Yes,
say it's
okay.
all wrong, but there we go. Before I explain to you the protection offered by the Employment Rights Act for whistleblowers, I wanted to address some of the earlier questions about what the limiting factors are, so what the ambit of whistleblowing protection is. It's obviously not the case that every time you raise some wrongdoing, regardless of the context you raise that wrongdoing, that it amounts to protected disclosure, and that any retaliation in relation to that is prohibited by the legislation. There are in my submissions three key limiting factors in terms of the ambit.
Sorry, just so I get my note right, you said your submission did a focus on 2 points, but this actually isn't about either of these
Well,
points.
the first of my points is the protection under the Employment Rights
Oh, I
Act
see, okay.
1996.
Okay.
So we are into the protection of the Employment Rights Act
So I see, okay,
1996.
so three points, yeah.
But I'm just answering the queries earlier about the ambit of the protection under the Employment Rights Act 1996. And if I could start by taking you to page 9 of the authorities bundle, which should hopefully be in everyone's first bundle for the authorities. Page 9 defines a protected disclosure, and a protected disclosure is defined as a qualifying disclosure, and we'll come to that in a moment. That's the first limiting factor, which is made by a worker in accordance with any of sections 43C to 43H. So that's the method of the disclosure. That's the second limiting factor. So starting with the first limiting factor, that is on page 10. Section 43B defines the scope of disclosures that qualify for protection. So any allegations of wrongdoing made that fall outside of section 43B do not qualify for protection. The second limiting factor, as I said, is that the qualifying disclosure has to be made by a worker in accordance with any of sections 43C to 43H. You've already seen section 43C, which is on page 12. And you've also seen section 43D, which is disclosure to a legal advisor.
Right, we've seen all of them, haven't we?
Yes. Section 43F is particularly relevant in this case, my lord, because the appellant's position is that she made a disclosure to the council as a prospective employer, but also she says she made a disclosure to a prescribed person, her MP. And whilst there's disagreement about the primary, the first way in which she puts her case on section 43C, I don't understand there to be any disagreement that that would have been a disclosure to a prescribed person within
We've only
section
got limited
43F.
time. I think making point, which, as you say, isn't in dispute, isn't helpful. But yeah, thank
Very
you.
well. And then, as you've seen, section 43G is disclosure in other cases, and section 43H is disclosure of exceptionally serious failures. So that limits the method of disclosure. And lastly, the third limiting factor is what retaliation is prohibited by the Act. So as I've said, not all acts of retaliation are prohibited by the Act. So for example, if one makes a disclosure to me as a legal advisor, even if it's made in accordance with section 43D, if I then retaliate against you because you've blown the whistle to me, that wouldn't be prohibited by the Employment Rights Act 1996, because the only type of retaliation that's prohibited is that under section 47B or section 103A. You have section 43B at page 28 of the authorities bundle, and you have section 103A, the right not to be automatically unfairly dismissed, at page 42. So turning then to what the Department for Trade says in its submissions about justification, which, as I've already explained to you, is based on claims about how the legislation works, which we disagree with. The first claim is that made at paragraph 26 of their submissions, which is in the core bundle at page 64. It says, as to the purpose of the whistleblowing provisions of the Employment Rights Act, that is to enable workers who have access to information that the public may not otherwise have to raise concerns of a public interest, protect the public, but to do so in accordance with their duties to their employer. And a similar point is made at paragraph 67 of their submissions, which is at page 73, which you've already seen,
Yeah.
which suggests that it's to allow whistleblowing about wrongdoing in the workplace. But as you've seen, the whistleblowing protection is much wider than that,
Yeah.
deliberately wider than that, so that you can complain to your MP, so you can complain to the regulator, because it's in the public interest that individuals have those choices, particularly if their employer, a complaint to their employer is not going to achieve anything. So you've seen a disclosure doesn't have to be about wrongdoing in the workplace. It can be about health and safety. It can be about fraud. It can be about a
Well,
failure.
those are all wrongdoing in the workplace.
Sorry,
The health and safety and fraud are all in the workplace.
but they could be, but it could be about a client.
Oh,
It
well,
could be
that,
about
okay,
what a
well that's
client's
fine, but
doing.
your examples were not the right examples to make your point.
Well, forgive me. It can be about a failure anywhere in the world. Section 43B2 makes that clear. It can be about a failure to comply with a legal obligation that applies under the law of any other country or territory. And moreover, a disclosure can be about something the recipient is already aware of. That's section 43L3. So we say
All those are true, but it's very hard to see in practice how they are things that don't arise in the workplace.
well, my lord, they can arise in the workplace, but they don't necessarily have
Well,
to
give me
arise
some
in the
examples of
workplace.
ones that wouldn't.
So some obvious ones that wouldn't arise in the workplace would arise under section 43C, where you have the legal responsibility. So the disclosure to other responsible person. So
Okay,
if
but
you make a
give me the example.
So one example that's actually cited in the IDS handbook on this subsection relates to an employment tribunal judgment where a parking assistant employed by a company contracted to provide services to Westminster Council made a protected disclosure when he reported concerns to Westminster Council about the way that parking tickets were being issued. So he makes
Why is that not in the workplace?
well, it's not in his immediate workplace. He's making it to the
All
person
right. Well,
who's
the workplace is a
responsible.
metaphor. It
Yes.
means in connection with the work,
Well-
or in connection with the business of the employer, perhaps.
But the legislation isn't limited in those terms. There's nothing.
No, I dare
within-
say it isn't. But I want to see. I'm I'm sure we can think up fancy examples.
Yes.
But you did
But-
say, I'm so sorry.
Yes. But the paradigm, and a huge majority, will be connected with the work.
My lord, I don't dispute that, but we have a justification defence being put forward here on the basis that the legislation is to protect workplace, it is to protect individuals who who have access to information that the public may not otherwise have. But my point is that that's not just what the legislation does. It has a much wider.
I
offers
see
much
that,
wider
but I don't
protection
think
than
that's
that.
quite the force of the justification. I mean, however you draw the lines, one or two odd bits and pieces will come in that needn't have, or will be left out that should have been. But he's talking about the broad thrust, as I understand it. And the broad thrust is this is about things that happen in the workplace,
Well, my lord,
in the metaphorical sense of to do with the work.
well, there is no requirement that the disclosure relate to the employer, or that it relate to
No,
your immediate
I see that.
workplace, or that it relates to the employer's information.
I see that, but there we are.
Would you disagree with a description that says the aim of the Act, as originally enacted, was to protect workers, i.e. those in a contract of employment or analogous situation, from unacceptable action by an employer if the employee makes a protected disclosure, and it was then extended to a subset of job applicants, those who applied for applications to the NHS body for employment. So we don't get into the details of what and when. It's to protect workers or to protect a subset of job applicants from adverse action by their employer or prospective employer.
My lord, we've spent an inordinate amount of time on that query already, but I think we would say that what we're worried about here and what we're responding to is the justification being put forward by the Department for Business and Trade.
By asking a
And the
different
justification being put forward by the is quite different from the legislative aim. They do rely to an extent on the purpose of the legislation, but what they are justifying is the difference in treatment. So why job applicants aren't protected, whereas internal job applicants or NHS applicants are protected. That's what they need to justify, and they need to have a legitimate aim to
Well,
justify that
I
treatment.
think what's been put is that, broadly speaking, and this we can think of exceptions, but broadly speaking, people who are in employment are likely to have a lot of subject matters to whistleblow about, and people who are not in employment aren't.
My lord, I'm not sure that's true. I think if you ask your average undergraduate student nowadays, that they might say that they've got a lot of things that they're concerned about, which might actually fall within the definition of protected disclosure. It's just that the legislation hasn't led. There's
Well,
no legislation.
when
that
you get your
protects-
first job as a student and you complain about what the things was like in the junior common room, that's not likely to lead to you being discriminated against.
I'm not saying that, my lord, but I'm saying that I'm not sure it's right to say that workers have more concerns than anyone else. But anyway, my simple point is that
That's why I was going to ask you about your third limiting factor, because that comes from section 47B.
yes,
So even accepting your submission for the sake of argument, that protected disclosures can relate to a wide range of subject matter,
yes,
the protection which is triggered is defined by subsection 1.
indeed.
And in most instances, from a practical perspective, since it's got to be an employer who acts, it's likely to be workplace related or have some impact on the workplace
Well,
or the work.
I think, my lord, I'd slightly nuance that and say
I couldn't get it entirely right.
not still, but my lord, I'd say what we're concerned with under section 47B is the prohibition against retaliation. And when is an employer most likely to retaliate? Well, if they're worried about what the individual blew the whistle about.
Exactly.
So that's the
As
prohibition.
opposed to someone just acting arbitrarily.
Indeed. So you have my point in paragraph
But we certainly have your point. And
26. Yes.
okay.
27. There it says,
I should say your half hour is up. We've asked you a lot of questions. I'm not to stop you now, but you're going to have to
Indeed.
keep an eye on your time.
Yes. Paragraph 27, it is said that a protected disclosure must usually be made to a person's employer. But I think you've seen from section 43C to section 43H, that may be a typical case, but there's no statutory presumption to that effect. And nor is it right that there's anything that requires that in the legislation. Then at paragraph 32 of the department's submissions, it is suggested that the purpose of the legislation is to protect the public by enabling those in the workplace to raise concerns
So
responsibly.
sorry, which paragraph were you on? I was just
Sorry,
thinking-
paragraph 32, which is on page 65.
Yes, thank you.
And in fact, in the workplace is underlined. But of course, as has been explained to you this morning, it doesn't just protect those in the workplace, it protects those who were in the workplace.
Yes, but that's just playing with words, really, Miss Darwood. We know what this is talking about, and I would put it differently if I was doing the skeleton. But the point is that it's to protect people who are in or have been in a contract of employment or are an applicant for an NHS job. And to say workplace doesn't cover those who've been sacked, I just don't see that it helps really in the great scheme of a case as important as this.
Well, my lords, I'm here to help you understand the legislation. It is said in paragraph 32, enabling those in the workplace. My point is it's in and outside the workplace. You have to have been in the workplace beforehand, but you could now be outside the workplace. Paragraphs 33 to 37, there is a suggestion that the protection under Article 10 and under the domestic legislation are one and the same, and that you would have to fall within the Halleck criteria to
Sorry,
benefit.
what are the Halleck criteria? I didn't.
Those are the criteria that are listed.
Oh,
at
Hallett. Yeah, sorry.
Yes.
Speaking of Dame Heather.
Paragraph 36.
Yeah, sorry.
But my lord, you're obviously not concerned with a pure Article 10 case. You're not looking at Article 10, and any justifications than Article 10.2. It's common ground that the facts are within the ambit of Article 10. So I don't agree that there are limitations on the domestic legislation in line with those criteria. The second part of my submissions focus on the NHS regulations. You've seen section 49B, but I just wanted to show you how applicant is defined under section 49B. Page 36 of the authorities bundle is section 49B. For arguments purposes, there's been much discussion of internal and external applicants, but of course that's not how applicant is defined under section 49B2. It's an individual who applies to the NHS employer for a contract of employment, a contract to do work personally, and so on.
But I'm not quite sure what point you're making. Obviously, it means what it says, but what this adds is effectively external applicants, because internal applicants already have a right because they are already employed by the employer.
As against their current employer,
Yes.
but they wouldn't have a right if, say, they applied for a job with the Care Quality Commission, they're employed by an NHS trust.
Well,
they would have no protection if the Care Quality Commission decided not to employ them because they've blown the whistle to their NHS trust.
exactly.
So,
Well, maybe
internal-
we're at cross purposes, but yeah.
So internal, I suppose, my lord, if you mean just you're employed by an NHS trust vis-a-vis that NHS trust, but if you mean internal as in internal to the NHS, this gives them a right once they're employed by the NHS as against another NHS employer.
Yes.
But it also, as Lord Justice Lewis pointed out, gives you a right if you've never been employed by the NHS. And it also gives you a right under this not to be discriminated against because you made a protected disclosure. Even if you've never been in employment at all, if you're a student straight out of university. And of course, as you've heard, there isn't one unitary employer within the NHS.
Yes.
It's commonly by an employment would be by an NHS trust, but this has been given an extended meaning, so it would also apply to, say, the Care Quality Commission. The protection under 49B is a protection not to be discriminated against. And if you can see, the definition of discrimination there is if the NHS employer refuses the applicant's application or in some other way treats the applicant less favourable than it treats or would treat other applicants in relation to the same contract. And then the prohibition is at section 49B1 and also in regulation 3 of the regulations. And that is from discriminating against an applicant because it appears to the NHS employer that the applicant has made a protected disclosure. So that's a form of perception discrimination. It's somewhat wider than the Employment Rights Act 1996, where the discrimination that's prohibited has to be on the grounds of making a disclosure.
But it isn't as wide as detriment.
My lord, it would be. It's just the causation is different. So you have to prove that you actually made a protected
But on the ground of
disclosure.
includes perception as well, doesn't it?
My lord, sorry?
On the ground of you includes perception as well. I'm just wondering, was this deliberately drafted this way in order to be wider? I thought it's just using the same different word language to achieve the same results. It doesn't
My
really
lord,
matter
it's
for our
different.
purposes.
It's different from the causation test. Whether they have the same meaning, I'll leave that for another day. But it is slightly different in terms of
Differently
the scope
worded,
of the
I see
prohibition.
that, yes.
Yes. And you can see that it's not just against the refusal of an application, but it would be any form of less favourable treatment. And why this matters is what is said by the Department of Trade, and it's paragraph 67 onwards in the submissions.
Which page?
It's page 73.
Yeah.
As you've seen, and I know that Lord Justice Lewis takes the view that in the workplace also means out of the workplace.
No, I'm just saying you're playing with words. I was being rather critical of you, I'm sorry, and I do apologise. We know what he means. What he means is workplace connected, and in this case does not turn on whether or not this is inside a workplace or even after the termination of employment. It's clear that both of those are connected. The question for this employer, this applicant, is whether she was less favourably treated in a way that contravenes Article 40 as read with Article 10. It's not going to turn on wordplay.
But obviously, on any view, the NHS regulations protect individials who are outside the NHS, don't even need to be in
I'm so
any
sorry. I'm
employment.
behind you. This is another criticism of Mr. Moreto's
Yes,
submissions.
I'm afraid
Which
I'm still
paragraph are you
criticising Mr.
criticising?
Moreto's submissions.
Which paragraph?
I was looking again at what was said at paragraph 67 and 68 about
Right.
being in the workplace.
Well, we've looked at that point already.
But under the NHS regulations, it's a slightly different point, my lord, because the NHS regulations on any view apply to someone who's never even been employed.
Oh, for
Yes.
yes, but yes. All right.
Yes.
We did say that this morning.
And then at paragraph 72, sorry, forgive me. Forgive me. A paragraph. Um, 69, it is said that,
59,
69, forgive me, page 73. In that respect, a person who is not in employment in an organisation.
Sorry, I've got lost. 59.
69, my lord.
69, sorry.
Sorry. In that respect, a person who is not in employment in an organisation and is merely an applicant is clearly less likely to be in a position of having access to confidential information showing wrongdoing by that organisation, which they need protection from if they disclose it responsibly. And it's the same point, my lords, which is that justification can't apply to NHS job applicants.
But it can't apply to some of them, no.
Well, my lord, he's got to justify it. The burden is on
No,
him.
Parliament
and-
has to justify it. He's doing his best to help them, yes.
Well, there we go. We respectfully disagree on that. So paragraph 71, and then there's an example there given about wrongdoing in the workplace. But of course, that example is premised on the fact that disclosures are limited to wrongdoing in the workplace. Whereas I've shown you, it could be about an environmental disaster. It could be about health and safety in an entirely different context. And it is then said that the difficulty is that a new employer would not therefore be able to investigate whether it was appropriate for the applicant to disclose such matters to them in the first place, in light of the employee's duties of confidence to their previous employer. But firstly, the duties of confidence don't apply in this context, and that's specifically made clear under the legislation. But in any event, the prohibition is merely on retaliating. So you retaliate in relation to the fact that you've made a protected disclosure. So we say that's no justification. Just on the issue raised about the definition of an employer, which I think was one of the questions raised by Lord Justice Holgate earlier, you've seen obviously that there's an extended definition of worker, and that's been achieved by section 43K. So if I could just take you back to section 43K. It's page 21 of the first authorities bundle. And wanted to take you in particular to what is said under section 43K1B, where it said contracts or contracted with a person for the purpose of that person's business for the execution of work to be done in a place not under the control or management of that person, and would fall within section 233B if for personally in that provision there was substituted whether personally or otherwise. Quite a long-winded way of saying there need not be personal service.
Well, we know.
Yes.
Why is all this relevant to the issues before us?
It's relevant, my lord, because, say, for example, the Deliveroo riders, who the Supreme Court have held not to be workers, because there's no personal service, they can send a substitute along. They are workers uniquely for this purpose.
Yes, well, I understand
They
that.
wouldn't be workers under any other piece of
Well, I'm
legislation.
sure I understand that. We all know that. But why does it get us?
It gets you to the fact that Deliveroo is an employer for the purposes of this legislation,
Yeah.
because the extended definition of worker has a
But where does that
corresponding.
get us? All it shows is the definition of worker is particularly, uniquely wide. But how, on the question about the justification of excluding job applicants, which is what this case is about,
Yes.
how does that fact make a difference?
Well, my lord, where it gets you is not only is the definition of workers uniquely wide to include people who categorically are not workers in any other context,
We've got that point, yes.
but the definition of employers is uniquely wide to include individuals like Deliveroo, who under no other context are employers.
Of course, that's the other side of the same coin.
It's the other side of the same coin.
Still, you answer my question.
And so, my lord, where it gets you is that when you are concerned here about job applicants, the definition of employer wouldn't be any wider, because it would still be somebody who's looking to recruit and somebody who fits within that extended definition of workers. And that's relevant to the justification being put forward, which is a justification that seems to be premised on a very traditional relationship, whereby individuals are in a workplace in a traditional sense and have access to information in a kind of sense that you might if you go into the office Monday to Friday, 9 to 5.
I'm not sure that's right. But surely, if a Deliveroo driver were making a whistleblowing complaint about the health and safety of the things they carry the food in, that would be covered, and that doesn't create any difficulty for Mr. Moreto's position, does it?
Well, it's my point on his justification defence is the entire justification defence assumes traditional employment relationships.
Well, I'm wondering whether it does.
Narrow.
That's what I haven't really understood why you say it does.
Well, I think if you read the sections and if you read what
Which
he
paragraph
says,
in his Sullivan argument falls into that error?
Well, so for example, paragraph 70 onwards, he talks about all the difficulties that might be caused if job applicants were able to complain if they were subjected to unlawful victimisation.
The problem that I've got with 43K1B, and that's probably my problem, and I do apologise, is that this is dealing with people who haven't got, as you call it, a standard kind of employment work scenario, but they've got to be people who've worked for a person in certain circumstances, or B, contracts with a person for the purposes of that person's business, for the execution of work to be done, not under the control of the management. And if they're doing that, it's a very different type of work from the standard going to the office 9 to 5.
Yes.
I can't, with the very greatest respect, see how that is relevant to whether or not applicants for a job who've got no kind of contract at the moment for the execution of work to be done and are applying for a job. It is a really different set of people subject to the NHS exception.
Well, my lord, it's common ground, and everyone accepts that the legislation doesn't currently protect job applicants.
Yes.
So I'm not trying to pretend that Section 43 covers job applicants on a literal interpretation.
So how does it help us?
Because I'm responding to the justifications put forward.
Yes, well, you were going to take us to the place in Mr. Moretto's skeleton argument where he appears to advance justification arguments that only work for conventional employment.
Yes.
Which paragraphs are those?
So the justification section starts at paragraph 66 on page 73.
Yes.
And in my submission, what is said from paragraph 66 onwards is centred around a overly narrow interpretation of the whistleblowing
Just
legislation
show us where that
and how it applies.
It just talks about workers.
Yes.
Obviously, workers within the meaning of the Act, the
Yes.
extended meaning. Their
Yes.
workplace within the extended meaning.
Also,
I
for
don't
example,
just see where. I don't want to give you a hard time. I'm just trying to
No,
see
no.
why this is important.
well, so for one example is what's said about a duty of confidentiality. Well, a duty of confidentiality is something you would often associate with a traditional employment
But you
relationship.
could easily have it in a Deliveroo type,
You
in
could.
an independent contractor type situation as well.
You could.
If you've got an IT contractor, it may be very important that they have a duty. Is this your best point to start? We're spending a lot of time on it, and we.
No, my lord, I was responding to your specific questions about this, but
Well, no, don't be.
Yes.
Of course you were, but it's because I was trying to understand what you were getting at. And now I think I have.
yes. Well, I think then we'll move on, my lord.
Yes. How
So-
much longer do you think you need?
Not very much longer, my lord. So you've had my submissions on the NHS regulations. You've had my submissions on the Employment Rights Act.
Yes.
And you've had my submissions on what's put forward as the justification by Mr. Moretto and the particular difficulties that he says that might arise, which we say just don't arise and aren't reasons that would justify the difference in treatment. And so we say, in all the circumstances, that justification hasn't been proved here.
Okay.
One further issue, my lord, that you specifically asked
Yes.
a query about was what happens when an employer doesn't justify a difference in treatment for the purposes of Article 10 and 14, or I think it was actually...
Did I?
You asked a query about private employers and the need for the Secretary of State.
Oh, yes. Well, I was just asking a practical. I've been
Yes.
very grateful for your experience on this. I mean,
Well, the
detective are uniquely well placed. Do they ever intervene in employment tribunals?
my lord,
Once
I'm
they
not
do-
sure that,
No.
that they don't, but
Still,
I
they'll
wanted-
know the history of the cases in which they do intervene.
indeed. But I just wanted to make you aware, my lord, that you have Steer and Stormshore in the bundle,
Yes.
and the same issue arose in that case, which was the government legal department was asked to intervene at the EAT stage, didn't, the EAT then held that justification hadn't been made out in the absence of anyone advancing a
Yes, I see.
justification.
Oh, that's very interesting.
And then the GLD did intervene, and then it came before the Court of Appeal. And
And what
you
did the
have
Court of
that.
Appeal say? Did it say too late, or did it say in the circumstances we better look at it?
They dealt with it pragmatically as
Can we look? Can we
parties
just
have
briefly
here.
look at that?
Of course, my lord. It's tab 28 in the bundle. Oh no, forgive me. It's page 1415 is paragraph 24. No, it was tab two.
tab 28?
No, it's forgive me. It's tab 44. The paragraphs of relevance that I picked up are paragraph 17, page 1412. Notice is given to the government legal department, but they essentially don't do anything. There is then a hearing in the EAT, and Mr. Justice Kavanagh's decision on justification is set out paragraph 24 on page 1415.
Yes.
He says the question of what standard of justification is applicable in this
Well,
case
don't just stick to the point about how the Court of Appeal dealt with.
is moot.
That's
And
right.
then how the Court of Appeal dealt with it is paragraph 28. Secretary of State can't be bound by concessions as the law made on behalf of the respondent company in the Employment Appeals Tribunal. So I think that's the exact same position as today.
It was dealt with pragmatically on the merits. Okay, well, it's useful to know that what we're being invited to do by everybody here has some pedigree.
Yes.
Thank you. That's been extremely helpful. I think we better, if you do
Indeed, my
just-
lord, unless you have any further questions for me.
No, if at some point somebody can spot the case in which we looked at the legislative history, you can let me know at some point.
Yes.
Right, now, Mr. McCombie, do you want to make a start?
I can do, my lord.
Yes.
I know the
How have
time.
you divided matters up between yourself and Mr. Morato?
I am leaving questions of justification entirely to him.
Yes.
That is my plan, and I think he's on board with that, my lord.
Yeah.
On
Fine.
the-
So that
it's
will
all my
obviously
evidence,
reduce quite significantly what you have to address us about.
It will, and indeed, by reason of the discussion that you've already had, I can summarise a lot of the points I would have been making.
That would be very helpful.
You have the issue. So I represent the respondent Isle of Wight Council, assisted by Louisa Simpson, who's sitting behind me, instructed by their internal department. The way that I was proposing to deal with matters in terms of my submissions was to take, first of all, the question of who is and is not protected by the law as it stands, before moving on to identifying the situation of this particular applicant, the matters that Mr. Jupp referred to this morning as the two
Yes.
lady points. Then go into the Article 14 questions, the questions of justification from Mr. Moretto, but before getting to him, deal with
Yeah,
remedy.
okay,
From
well,
my
off you go.
perspective. So in terms of the protection under the legislation, you've by now heard a lot about Section 43B. Whatever the width of the protection that it affords, it is clear that the specific employment need not be, in principle, the source of the protected disclosure, although in practice it usually will be. Woodward, the case of Woodward tells us that the regime protects former employees as well as current employees.
Yep.
BPN Elstone tells us that the disclosure upon which basis detriment is done need not have been made in that employment, in the same employment that detriment is done in or the dismissal is from. Onyango tells us that the disclosure itself may come after termination of employment. All these are points that seem to pass without difficulty in front of your lordships this morning, so I go through them fairly quickly. McLennan is perhaps the case where I do part company from Mr. Jupp, because what he said, McLennan being the case, of course, where what's decided is that the worker, the president-elect of the British Psychological Society, is protected from a detriment by that employer for a disclosure made prior to commencement. What Mr. Jupp said was that the
By the
only
commencement of
prior to commencement of the the work relationship, to taking up the post.
Before the
as
contract
president.
of employment started, yeah.
Yes, effectively. So, what Mr. Jupp said this morning was that the only distinction between that case and this one is that in that case the job applicant was successful. But my submission is that that obscures the real issue, that the president-elect in fact became the president. Point being that he then participated in the workplace, and it was that participation that meant he was afforded protection under the Act.
It may be unhelpful to keep using this word workplace. He participated in the work.
Well, my lord, yes.
You need to add on the word place.
It may be.
In the virtual sort of work that
And lots of
people
people
do.
work from home.
It did.
Some people never go near a workplace.
Yeah. He worked as the president,
Worked.
having been elected to that position. So it's not simply a question of being successful as opposed to unsuccessful. The point is that the right of action was given to him by virtue of the work. Whereas if the applicant is unsuccessful, that doesn't
That
happen.
doesn't really help you because, say, on the 1st of May, he was appointed. He made a disclosure on the 31st of May. He's appointed on the 1st of June. They discovered this disclosure on the evening of the 1st of June before his contract is due to begin the next day, and they sack him immediately. Well, no, his contract started 31st of May disclosure, 1st of June, 10 a.m. contract starts. They discover at 4 p.m. he's been bad-mouthing society. They sack him summarily that afternoon. He may have done nothing yet, but he would still be protected.
Well, that would be, in my submission, just a case where the law in the end has to draw a line somewhere.
Yes, and it's the contract starts.
Yeah.
And there may well be cases on the margins of the sort that your lordship describes where you could say it's difficult to maintain the exactly the same submission, but the general point remains that once one becomes tied to the work, that is when the protection kicked in. So it's not just a case of saying there's a difference in the quality of the applicant. It's a difference in the way, in the relationship between the worker and the work.
But the way I've been putting it, but nobody seems interested, is that what the Act seeks to do is to protect people who've got rights and duties under a contract of employment and a subset of applicants from having unacceptable things done to them by an employer or the NHS body. So we don't get into the weeds of when precisely would or wouldn't it occur. The thrust of it is to protect employees and NHS job applicants from adverse reaction to disclosure.
Your lordship summarises where I get to with this part of my submissions, because the next case that I would have been referring to in more detail had not been covered this morning is Tip Lady, which is
What, sorry?
is Tip Lady,
Oh yes, right.
which is the
We weren't actually taken to it this morning, but maybe we don't. We've certainly all looked at it. But anyway, see what you're going to say about it. And we'll
well,
see if we
it's simply this, that the detriment must be suffered in the worker's capacity as a worker and not in some other capacity. So the issue in Tip Lady was that the local authority employee there had a dispute with her employer about a property
Drains.
matter, about drains, sewers, and I think there was another issue as well.
planning.
But there were property disputes,
Yeah.
which she had with her employer. And the decision was that the detriment ultimately suffered by reason of that dispute was not suffered as an employee, but was suffered independently of the work relationship.
Yes.
And on that basis, there was no detriment that was actionable under the Employment Rights Act protected disclosure regime. So it's about suffering the detriment in the capacity of the employee within that work relationship that has been established, rather than some other basis for action.
And that's focusing on section 43B.
Yes.
Well, irrespective of the nature of the protected disclosure made previously.
Yes, because if
There may have been a protected disclosure which related to the work, but once you come to claim the protection of 43B1, if it's not related to your capacity as a worker, it's neither here nor
well,
there.
that would be under section 47B, but the point,
Or 47B.
the-
sorry.
my lord, yes. If the detriment, if for example, by reason of that dispute about property, she had been dismissed or disciplined in some way, well then that would have been actionable because that detriment would have been suffered in the employment.
Oh,
So the right of action would have, it doesn't matter what the disclosure was about.
I can't remember
What
what the
matters-
detriments were, but as you said, the detriments were not employment detriments.
Exactly.
They were council officials being
I-
rude when they
indeed.
came to measure the drains or whatever it was.
Indeed.
Yeah.
But
something like that.
the point of distinction in the case is that the detriment wasn't actionable because the detriment wasn't suffered as an employee.
The clearer cut example is the decision which we approved of the council worker who, where the detriment he claimed was being prosecuted for some parking offence or suffering a fine for a parking offence. I think is that. I can't remember. That's one of the cases referred to in tip. The point is the detriment has got nothing to do with the employment context.
Yes, that is the point. So that is tip lady, and the protection in all of those cases is tethered in some way to the work. That's the real point. It's not free floating of any of those kinds of obligations. It arises from the work. That is how the right of action arises. That's what these cases all have in common. The reason that is important is that the Article 14 test, which the court has to engage with, has to identify the situation of this applicant as against some protected class that she does not fall within. So identifying the nature of the protection is important in the comparative exercise that the court has to perform. Now, the extension of the Employment Rights Act regime follows two separate models. One is the deeming provisions which call people workers and bring them within the regime who might not obviously be so. That is entirely consistent with the work model because it simply says, look, these people who would often be thought of as workers might naturally be thought of as workers. We will deem them to be workers for the purposes of these provisions. So it meets the agency test. It satisfies the Deliveroo example that Starwin was referring to. Those are the Section 43K situations. The other model is the NHS employer example, where the extension goes further than people performing the work into applicant situations. But there the protection is limited to either refusal of the application or matters relating to that application. And the comparator group is defined as other applicants for the same post.
So the nature of the protection goes with the status of being an applicant.
Indeed. It is the other side of the coin of being the applicant in the sense that if you get refused, here's the protection from that detriment. But
you don't get protection as wide as detriment as you do under Section 47B.
It is restricted to either the rejection of the application or some connection. We better turn up.
It is the phrase uses, I think, less favourable treatment.
It is less favourable treatment, but it's
in practice it is detriment.
Yes, but it's a more restricted version.
But
of
it's a
detriment.
particular type of detriment.
Relates. So it's at page 36 of the authorities bundle.
Yes.
So you've got the definition of applicant within subsection 2 there. And then subsection 3 is the definition of discrimination in this context. If the NHS employer refuses the application or in some other way treats the applicant less favourably than it treats or would treat other applicants in relation to the same contract, office or post. So you set up a hypothetical or actual comparator who's applied for the same contract, office or post, and you specify the, for want of a better word, detriment that will be actionable in this context. So
The first half deals with refusal.
Yes.
The second half deals with
effectively detriment, less favourable treatment.
but specified to be
In the way other
relation.
applicants are treated.
Yes, and in relation to the to that same application, in effect, the same
Yes.
contract office or post. So it's a less extensive version of protection.
Application focus.
It is.
I won't use the word place.
No, it is. What this claimant is asking the court to do is to say that it's the first model of protection that seeks relief. So she wants to expand the definition of section 43K. She is not saying, as I understand the submissions to be, that in some way this definition of applicant should be extended to all applicants, the definition that appears in the NHS category. What she's asking for is the protection from any detriment on the worker model.
Yes, the 47B protection.
Yes, indeed. Yes. And I say that becomes important when you perform the comparative exercise, and it's important for justification, it's important for remedy.
Because the differential treatment embraces the difference in treatment under the statute.
Yes.
Whether it be 47B or, if relevant, 49B.
Yes. And the way that I understand the case to be put is that she compares herself to these two different types of either worker or applicant who have the protection that she doesn't have. And so it's about comparing those categories to her situation. So,
But say you had a case where the only complaint was I'm being discriminated against relative to NHS applicants. If that was the sole complaint and it was accepted by the court, the remedy would be to read in words equivalent to 49B3.
it would be.
Or their equivalent. It wouldn't be to read in words equivalent to 47,
Well, yes.
sorry, B1.
It would appear to be.
Because it's not a relevant difference in treatment to the way the claim is put.
That ultimately, my lord, is where I end up in terms of submissions on remedy. On one view of it, it comes down to if you were to get that far and perceive there to be a difference in treatment that infringed Article 14, what you would have to do is to work out precisely on what basis that was occurring and tailor the remedy to fit.
Exactly. Identify what is wrong, identify the discrimination that has occurred, and tailor a remedy to rectify that discrimination.
Precisely.
If it's workers, it's a broad remedy. If it's NHS applicants, it might be a narrow remedy. But that's a technical process that not be beyond the wit of a human being to do.
But one of the problems with the appellant's case here is that the remedy that's being asked for doesn't meet the problem identified in respect of at least one of the comparators she seeks to rely upon.
Yeah.
It's not enough just to say, well, there are all these various categories of other people who have the protection that I don't have. So give me this particular remedy for this particular category. We make submissions on it more, I think, when we get to remedy, but that is one of the difficulties with the comparative exercise that ultimately.
Well, at that point, point tomorrow.
Yeah, indeed. That's all I was going to say anyway, just on the question of where we've got to in terms of the legal protections. I was going to move on to this particular applicant's situation. I can do that tomorrow morning.
It seems to me likely that between you and Mr. Moretto shouldn't last more than the morning,
I think that is likely,
given the ground we've already covered.
given the ground we've already
Honestly,
covered.
we may slow you down.
It may get more difficult when we come to the Article 14 questions, but again, there's plenty of ground that's been covered, and I don't need to refer the court to more than 4 or 5
Good. Okay,
checkpoints.
well that's fine. 10:30 tomorrow.
All rise.